David Seltzer is also with us, a great criminal defense attorney down in Miami. David, when I think about the picture that is being painted in that courtroom, when you look at the Youngs, the husband, the wife, the mother, the father, the victim and the defendant, there's another huge contrast here, and that is how much this mom wanted to be a mom, how much this wife wanted to be a wife, which seems to me to be the exact opposite of the defendant. The dad who didn't want to be a dad, the husband who didn't want to be a husband.
But all that tells you is what Beth was saying is prejudicing the jury. My favorite term of art for these prosecutions is smoke and mirrors. We saw it with the Casey Anthony case. We see it in major homicide trials. The state has nothing, and a jury of his peers, of our peers, whatever you want to call it, already told them they had nothing when they lost 9-3 last time. So to me, they're trying to just take a second bite at the apple, and all they're trying to do is prejudice the jury against Mr. Young. The evidence hasn't changed from one case to the next. It's still the same. They don't have enough to convict.
Okay, but when you call prejudice, someone else might call evidence in the case, might call motive in the case, right? This is, I mean, because the first question everyone wants answered when you have allegations that a man kills his pregnant wife is, why on earth would he do it? So,
correct.
Doesn't this get to a certain extent, whether you believe it or don't believe it, but to a certain extent, it would explain a motive here. Why on earth would any husband or father want to kill his pregnant wife? Well, if he didn't want to be a husband, he didn't want to be a father, that would be one reason, wouldn't it?
It would be one reason, but you're talking about the most extreme reason. There are so many alternatives in the middle: separation, divorce, other alternatives. Now, forensically, I don't believe they can prove this case beyond exclusion of all the reasonable doubt.
You can't divorce yourself from fatherhood. You can't divorce yourself from fatherhood.
You can't. I understand you can't. However, murder is a huge step, and you know what? You can be a deadbeat dad all you want, but murder is a huge leap to take. And forensically, I don't see this case having the evidence to prove it a second time.
Well, what I think, and we'll get to the evidence. I mean, I think today, and some of this testimony is about motive. Beth Karras, let's listen to a little bit more of Linda Fisher first, the victim's mom here, because
this time around.
David Seltzer, I got to ask you about that. And here's, if you can prove that someone is lying about an alibi when they are a suspect in a murder case, is that evidence of anything?
One may argue it is evidence of. One may argue that it is evidence of guilt. However, you have to expect that they already had the evidence at the last trial, being the testimony of the defendant. So it's not something new. I understand what Beth's saying, how they've had time to review it, dissect it, and inspect it, and they're trying to disprove it. But you know what? They knew what the evidence was at the last case. They had the testimony at the last case. They had an opportunity to analyze it before they did their closing arguments. They had an opportunity to dissect it. So 6 months later, however long the time of lapse was between retrials, I don't think that changes too much. I don't think it's going to be a huge difference for the defense. If he chooses to take the stand in this case, you can bet your bottom dollar he's going to be testifying identically as he did in the last case. Nothing's going to change. So I don't see much of a difference in this case.
It's a tough one. This is not an easy one for prosecutors, folks. Not at all. Not by a stretch. Let's take a listen to more of the testimony of Linda. David Seltzer, should the defense be concerned?
As a defense attorney, I'm a little concerned, but not much, because here's my argument. They should have had this at the first trial. What's changed? Why all of a sudden, after the defense made their arguments, do we have blood downstairs? They went back and traced their footsteps. This is a murder scene. You have the cream of the crop, investigators investigating a murder scene. So they missed it the first time, but now all of a sudden, after the first trial, they find this evidence? I find that a little suspect.
Well, let's talk about the cigar. Amanda, is there any photograph or picture or anyone who ever testified about this guy liking cigars? Was there a cigar butt found outside the hotel? Is there any evidence of a cigar?
Not to my recollection. And again, we're using Jason Young's own words from his testimony at the first trial, where he said, you know, I did prop the door. I did go outside for a few minutes, and I was smoking a cigar. We heard even today from one of Michelle Young's friends on the stand that she had been a smoker, Michelle Young, early on. and that Jason had said, I don't like smoking, please don't smoke. So again, it's a very subtle, small piece of evidence, but I think it's one that the prosecution is going to use. And of course, we still don't know whether or not Jason Young will take the stand in his own defense in this trial.
Yeah, we're not going to know that for some time now. All right, David Seltzer,
I got 2
how about
points
the
here.
cigars?
I got to say 2 things. Okay, first of all, if you ask me, I don't smoke. Have I ever smoked a cigar? Yeah, once a year on a special occasion, I'll go out and smoke a cigar. So people who smoke will smoke cigars. It's not an uncommon thing for someone to be asked, do you smoke? The answer is no. But maybe occasionally you'll smoke a cigar on a special occasion. So I don't think that's a huge deal. The second thing that we keep bringing up is the toddler said daddy was home. People who have kids know kids say mama, dada all the time. So the fact that the kid said daddy was home or dada doesn't necessarily mean daddy was home at that specific time.
But there wasn't anyone else there, David. I think that's
it doesn't matter.
If
If you take a life lesson out of my house, if you call my house right now, my son is going to say mommy and daddy all day long when we're not home. It's just they're learning words. That's what they say.
Beth Karas, go ahead, Amanda.
Is that this is this child was 2.5 years old. So it is very difficult to discern, what did she know? What did she not know? What was she saying? I mean, obviously she could have been asking for her dad because something was wrong with her mom and she was upset. So it is going to be very difficult I think, to use anything that she said.
Kids under 5 have credibility issues and competency issues, so the courts know that, and the testimony is taken with a huge grain of salt.
Huge grain of salt, but the jury's going to look and listen for everything that they can. And Beth Karas, if a stranger was in that house doing this murder, and the child said that someone else was there, that would be huge for the defense, and the credibility, of course, would be bolstered by the defense of this child. But to me, that would be a big fact. But the child didn't talk about anyone else being there.
Yes, but I agree with everyone that this is not great. And I think if I were summing up in this case as a prosecutor, I'd throw it in there, but I wouldn't really dwell on it. We covered a stabbing murder of a single mother years ago in Cape Cod, a fashion writer, and her little girl had her bloody handprints and footprints around her mother's body until it was discovered. And not long after the murder, that little girl, who was about 2 years old, was stood in the corner, and she was with a relative, and she was saying, "Get out of my house, get out of my house," as though she was mimicking her mother. And that was actually very interesting. I believe that the jury heard that.
Let's do this now. Let's go back to that first trial when Jason Young did in fact testify. David Seltzer, a crucial witness in blowing apart this alibi, but this is an eyewitness who comes with some baggage for the prosecution in terms of the disability that she has.
She does, and she does have some issues, and I think the jury answered those questions in the first trial by being hung 8-4, as you said earlier. So her testimony seems to be consistent in the second trial. Again, it's going to come down to a jury. That's really the only thing that's changed in the trial at the end of the day is you have a new jury panel. Whatever additional witnesses the state might add, whatever additional evidence the state might add, it really comes down to the forensics at this point. You have to remember, we live in a world of TV and Hollywood media, and everyone wants to see the smoking gun. Beth said it right. They had probable cause to charge this case, but it might not rise to the level of reasonable suspicion or beyond a reasonable doubt, which is the burden of proof that the state has to meet. And really, like I said, the forensics is what's going to speak for themselves, and that hasn't changed. So I think you get the same verdict at the end of the day.
Beth Karas, there was another case that we covered years ago on In Session. Nelson Serrano was his name. This is a guy, it was another alibi case, and the prosecution spent a lot of their time picking apart his alibi.